Welcome. You're watching the Moody Lawyer. Justice served with experience and integrity.
Hello and welcome to the Moody Lawyer with attorney Josh Moody. With a rich background in law enforcement and a comprehensive legal career spanning criminal justice, personal injury, and civil matters, Josh offers a unique perspective on navigating the complexities of the legal system. I am your host, Kevin Rosenquist, and today's episode is The Fault Factor, How California's Rules Affect Your Injury Settlement. Josh, welcome back.
Hey, thanks for having me.
So California's comparative fault rule seems to significantly impact car accident claims, but it's often kind of misunderstood. Can you break down exactly how this rule works and how it might affect the amount of compensation that a victim will receive if they're found partially at fault?
Comparative negligence is where maybe there's multiple people who were different with a different percentage or at fault for causing your injury. Contributory negligence is where a lot of times people get confused. I even see it in adjusters and with defense. Is contributory is when you do something to cause your own injury. So there's a difference between contributory negligence and comparative negligence. A lot of times it's splitting hairs, but that's what we do. So comparative is, well, maybe somebody is 50-50 for your injuries, but contributory is where you did something that was negligent to contribute to your own injuries.
And how do courts evaluate comparative fault when there are multiple parties involved in a car accident?
Well, there's only one entity in California that can absolutely make that determination. That's a jury. The trier of fact is what settles those disputes. So obviously when you're in negotiations, you're arguing for different percentages, and even in property damage claims, obviously percentages are always claimed, but you always look at what are we really talking about? Are we talking about somebody who blew the stop sign and somebody who made maybe an unsafe lane change or speed? So you have to look at what actually caused the injuries.
Okay. And what evidence is crucial in determining comparative fault in car accident claims? You mentioned the speed and stuff. What other evidence is crucial?
Yeah, it's the facts of the case. And that's always the thing. So I had one case I went to trial several years ago. Our guy was driving and he was driving the speed limit, and the other vehicle turned left in front of him. So the left-hand turn is obviously wrong. But the insurance company kept saying that our guy was speeding because they felt that there was a construction zone. Well, our argument was that he wasn't in a construction zone. The construction zone started several hundred yards to the east. So they're trying to put comparative and contributory negligence on him, and even trying to blame Caltrans for their setting up of the construction zone. So that those are the things that we argue about and fight over. And ultimately the jury found that, it wasn't a construction zone. And actually that one they ended up dropping, because when the experts testified, then they realized they were wrong. They were wrong. So those are the things that change. Those are the things that we deal with. Wow.
They even tried to, you said Caltrans, I imagine that's California Transportation.
Yeah. California Transportation. Of course, we always like it when Caltrans is at fault because they have unlimited budget.
Right.
So you kind of look at, what caused the accident? Well, the left-hand turn is what caused the accident. Whether he was going 10 or 15 miles faster because of the speed limit, a temporary speed limit, even if it was in effect, that's not, the speed limit isn't designed to stop people from making stupid moves in front of you. The speed limit is designed to keep the Caltrans workers safe. So it's designed to keep the workers safe who aren't even working on that street. They're working on the next street over. You just happen to see the cones that were set up. That doesn't make it a construction zone.
Sounds like that was kind of a shot in the dark.
They fought it tooth and nail.
Did they really? Yeah.
Oh yeah, I can't believe how hard they fought that. Yeah.
Wow. Interesting.
Yeah.
So obviously we've talked about it in the show. Dash cams are all the rage. People talk about them all the time. I have friends who have dash cams. What role does the presence of dash cams as well as traffic cameras play in determining the fault?
They're mainly evidence to show that maybe the other person isn't telling the truth. That's the biggest one. Again, another case, we had our client got rear-ended, but they were trying to claim that he had a green light. Well, it doesn't matter if he had a green light or a red light. If he sees a hazard and you stop in the roadway, the guy behind you is supposed to stop too. Well, which it wouldn't matter anyways, but we had a dash cam and it showed that the light was red and he stopped at it, and he stopped before, he didn't try to beat it. He didn't try to run through it. He stopped. So, those things help, but they were trying to put fault on him for stopping at a green light, which it's okay to stop at a green light, because what if a kid's running out in front of you? Right. What if the intersection is overloaded? What if there's a hazard? I mean, there's all kinds of reasons why you can stop at a green light. It doesn't give you the right to drive around them. It means you need to stop too.
Yeah. Yeah, exactly. Very good point. Especially if they're bigger than you and you can't see past them, you don't know why they're stopping.
Yeah,
you're going to assume they're just being dumb, but like you said, they're
sometimes they're being dumb, but unfortunately, you have a duty too to slow down as well. And that was another one. I can't believe they fought so hard. There's really no reason for that, but the dash cam made it easier, helped our case a lot.
Do you think everyone should have a dash cam?
Yeah.
Yeah.
Nowadays, yeah. For sure. And I think we talked about in one of our previous episodes, why not even inside the car? We require it of truckers because we want to know who's driving, and, obviously they cause more injuries, but inside the car, at least, I guess people don't want cameras inside their cars showing them, while we're singing along and, talking to whoever on the phone. So I get that, but, we're seeing it now with, Teslas and the other cars, like I think Rivian and these new electric, basically they're computers that have wheels.
Yeah. Right.
So we're seeing that, and that's where the future's going.
Yeah. That's how someone would end up getting outed as a Swiftie. Just being in their car.
Yeah. I wasn't listening to that.
What? No, that wasn't that was Metallica, I swear. So if a driver is found to be partially at fault, can they dispute that?
Oh yeah. And that happens a lot too. So in California, what typically happens is the property damage gets handled first. And a lot of times when property damage isn't resolved, it goes to like an arbitration between the two insurance companies about how the property damage is going to be paid out. And a lot of times adjusters will tell me, then you get to personal injury, and the adjusters will tell me, well, in our property damage, in arbitration, we got 50-50 liability. Well, good for you, because that's not binding, and it's a totally different standard in arbitration than it is when you're dealing with a jury of your peers. And the facts are the facts, and you need to have, we go off of jury instruction. So you show me what jury instruction that we're going to tell these jurors that says my client was wrong somehow, even 1% at fault. Tell me what jury instruction you're going to give to them that my client did that's going to make us accept any comparative negligence. And that's always my standard. But that's not the standard at like a property damage arbitration. They're totally different. But unfortunately, the insurance companies try to do whatever they can to limit their payouts.
Does disputing affect the claim at all?
Oh, yeah. Sure. I mean, if they're saying, we're offering, I'm just making these numbers up. We think this case is worth $20,000, but we're putting 50% liability on you, so we're going to give you 10. Well, guess what? Now we get past, let's say we make a motion or something, we find, and we get down to where we're showing, and we show that we're not at fault. Shouldn't your offer double right there? And that's one of their tactics too, is, okay, well, we would give you this much, but we're going to find percentage, so we're only going to offer you this much. That's pretty common.
Yeah, I would imagine. Is there anything that accident victims can do to protect themselves from being unfairly assigned fault in an accident claim?
Yeah, I mean, dash cams is a great one. Dash cameras, getting as many witnesses as you can. A lot of times, red light cameras too, because my client had the green light. What do they say a few days later? Well, I didn't say I ran the red light. So now it becomes an issue. Or a four-way stop sign. Let's say those are always in dispute, because then the other person never admits that they were. Or when they do tell the police and they say, well, I didn't tell the police officer that. Yeah. Okay.
Yeah. I don't know if I'm getting old and crotchety or if it's getting worse, but I feel like the very, very loose rolling stops are getting worse and worse, at least where I live. I mean, I can't even believe, sometimes I'm like, I don't even think you pressed the brake at all, So it's getting to be I feel like it's getting to be a bigger problem.
Yeah. And going more into comparative negligence. I mean, the other thing is, okay, look, let's say that you have more than one tortfeasor, more than one person who caused the injury. Both defendants are going to point the finger at each other.
Sure.
And a lot of times that can work in our favor, because now we're going to a jury, and the jury is going to see two defendants pointing the finger at each other. And my client here was injured, seeing that they're not, the insurance companies aren't doing what's right. But if they feel like they can save enough money, they're going to do it. And that happens, that happens a lot too, where two people will point the finger at each other and say, well, we're not paying. But the good thing is, in California, let's say one tortfeasor has a small insurance policy and the other tortfeasor has a bigger policy. If you find liability on either one of those companies, you can get 100% of your money from the side, whichever side has the bigger policy. Yeah. And then that defendant then has to go up to the other defendant for indemnification. that happens a lot because, again, their job and their issue isn't to really fully compensate you. Their mission is to get out as cheap as they can.
Absolutely. And I suppose I would imagine that there's a heavy, desire to lean on comparative fault with these insurance companies because it might be their best chance at lowering that claim, right?
Yeah, it's their best chance. And I did a lot of times, man, I see these cases, and a lot of times it's really these low limit cases that just, it's like we're arguing over, like $2,000. I mean, but that's how they are. I mean, like, yeah. I mean, and your excuse is I understand it when it's like a 7-figure, 8-figure case and, 5% can save you $1 million. I get that.
Yeah.
You're trying to put 25% liability on my client. That's going to save you like $2,000. And meanwhile, I see your insurance company constantly advertising at college football and the Super Bowl. Like what are we doing here? So it really is, they're different. Yeah. Like I said, their job is to get out as cheap as possible. And if it means, $2,000 to them by doing that, then for some reason that works for them. But yeah, their job isn't to make you happy.
Yeah, that's an interesting irony there, is the fact that they never want to pay out, but they spend more on advertising than like anybody else. I mean, you have a good point. Anytime you watch football, especially college football, it's like every other ad is an insurance ad.
Yeah. And they're spending, their advertising budget is not hurting. That's for sure.
That is for sure.
And, like I said, their job isn't, they're a business too. Their job isn't to fully compensate you. Their job is to get out as cheap as possible so they can run more ads.
Yep. They run more ads. Exactly.
And I don't know how it is in other states, but the insurance company is a very, very strong lobby in California. We're heavily regulated by the state, or they are heavily regulated by the state, and we're just all, you look on the billboards, you see, all the personal injury attorneys. We're not a part of this massive group. Sure, we belong to, law groups and we talk to each other, but we're not as organized as big companies are,
Definitely.
Not even close.
Not even close. Yeah. Can you share an example where the comparative fault rules significantly impacted the outcome of a car accident claim?
I don't know if it really changed, but I think we were able to maximize more money. One was where a trucker was driving down the road and he fell asleep. He crashed in the roadway. My client's husband went over to render aid to this person who fell asleep, trying to get him out of the car. And another truck that was driving by, going too fast, hauling a hazardous load, drove by and killed both of them.
Oh my God, that's awful.
It was horrible. Yeah, absolutely horrible.
Oh.
And the first trucking company didn't even want to talk to us. We're the guy who fell asleep. We don't talk to anybody pre-lit. You'll have to sue us. And even as we went through the process, it was like, we're not at fault. The other company's at fault for speeding. No offers, no nothing. And they ended up paying. It ended up, we set for trial, and we went to mediation, I think like 4 different times. And the company who was speeding was like, we know we're wrong. We know we're paying, but you guys got to pay too, because he shouldn't have fallen asleep. And I think they actually got out, we ended up getting more for our client because of how hard the first company fought it. They were just denying liability, and they were just pointing the finger. They wanted the other company to pay 100%. So we were able to get more money out of them, and that works. But that's how comparative can make a difference, comparative fault.
Yeah.
And going back to how truckers don't want to pay, they just didn't want to pay. I mean, it's a pretty simple case. I mean, you fell asleep.
Yeah.
That's the definition of negligence. So in that case, we were able to, it worked out. It definitely worked out better than if they had just come out and said, hey, sorry, we're at fault. Here's a check. Now go sue the other company. That may have worked for them at the beginning, but they didn't. That's not how they wanted to play it.
Yeah, they played it. They played it hard, and that may have been their downfall.
They played it very hard. And the other thing that, works on things like that, especially when you're talking like wrongful death, where there are things that we can do where we can get prejudgment interest. So if, hey, like you guys are making an offer of 0. So that means when you go to trial, you have to win 0. Meaning if I get $1, you're going to end up paying a lot of costs. But if I beat the amount of money that I want from you, that I'm demanding from you, I'm getting prejudgment interest. Mm-hmm. So start doing the interest calculations on a case that takes 2, 3, 4 years to go to trial.
Yeah.
We can make a lot more money on interest. Those are things that only an attorney can get for you. And the average person has no idea when to do it, what to do it, why to do it.
Yeah. Or how to do it.
Right.
What advice would you give to someone involved in a car accident about protecting their claim when they might actually share some fault?
Oh, well, I mean, the number one thing is just be honest. Don't lie about what happened. Just tell the truth, and just come to me or somebody who knows what they're doing, and we'll deal with it. I mean, unfortunately, sometimes there may be a case where you are comparatively at fault. Right. There was an issue. Okay, but we can still get you something. 75% of something is better than 0 of nothing.
Right.
You know,
That's very true.
so it just, a lot of times the facts speak for themselves. And, even if there is something that maybe there was some comparative fault, we can deal with it, we can work with it, and that's my job, and that's how we work with it. But honestly, I mean, over 90% of the cases that I deal with, I mean, there is no comparative fault. They're just trying to put it on you.
Trying to take down the claim. Yeah.
Yeah, it's a straight, it's a very straightforward, the vehicle code in California, it's over 100 years old. It's constructed a certain way. You're supposed to read it a certain way. And it's made to where, we call it, in California, it's called a primary collision factor. That's the number one reason. Why did this accident occur? Primary collision factor. There's one box for it. What's the reason? All the other reasons are not really, there is no contributory. I mean, there are, but the majority of it is one person's being negligent. It's not my client, who's just, typically is my client just following, as long as you're following the rules of the road, you're not negligent for the most part.
Yeah. For the most part. Yeah.
For the most part. I mean, there are exceptions, when it's raining, you can't go, speed limit. But I mean, for the most part, if you're following the rules of the road, you're not negligent, with exception. So,
all right. Well, thank you for tuning into the Moody Lawyer with attorney Josh Moody. To connect with Josh, head to moodylawyer.com, and please like and subscribe to our channel and leave us a review in the comments. Josh, it's always great to chat with you. Thanks for being here.
Thanks for having me. See you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.